In the famous case of Akbaruddin Owaisi, he was acquitted. He was acquitted.
Don't mention the name. That name should mention it.
He was acquitted, Speaker Sir, on the premise that the person who recorded the speech did not provide the original DVD-R to the investigating officer. But the speech was broadcast live and millions of people all over the country, all over the world were witness to it. But the court ruled that the digital evidence that was submitted before it was not admissible because the person who recorded the original DVD did not provide it to the investigating officer. So all other copies which were available online, which were available at the time of making of this speech, were not considered either as primary evidence or as secondary evidence and were rejected. This was a major lacuna in our Evidence Act. That has been addressed by expanding the definition of primary evidence. How the British tried to colonize, British tried their very best to remove from the memory, the civilizational memory of this country, our educational as well as criminal justice system that had been in practice for so long in the country. I must say today that when the country is the threshold of Amrit Kal, under the leadership of Honorable Prime Minister Narendra Modi ji, we have enacted the National Education Policy 2020, and today we are enacting these 3 Sanhitas, which is going to replace the colonial code, and in the true sense, we are moving away from colonization of education and colonization of our criminal jurisprudence. Today marks an important day also, Speaker Sir, because for about 160 long years and almost 7 decades after independence, the country's criminal justice system followed legislations which were made by the British, made for the welfare of the British, and made in Britain. Today, in those places, we are enacting a law that is made by Bharat, made in Bharat, and made by Bharatiyas for the welfare of Bharatiyas. This marks a very important step in our decolonization journey. In 1871, the British Raj enacted a legislation called the Criminal Tribes Act, under which large communities, large tribes were declared as criminals by birth, and they were subjected to multiple humiliations and restrictions. There were police manuals that were drafted enumerating long lists of how these criminal tribes must be dealt with, how they must be punished, how they must be abused. And for a long time, even after independence, Speaker Sir, many of our jail manuals contained these very provisions, and many tribes which were enumerated in these Criminal Tribes Act faced severe humiliations both legally and socially. Many of the major castes of Hindu society, like this was the word that was used by the British. Yes, it is unparliamentary. This was the words that were used by the British. Many of these communities, more than 130, 140 of them, they were declared as criminals by birth. And by 1947, at the time of our independence, more than 2 crore people existed in this country who were criminals by definition as criminals by birth. This was the intent behind the criminal justice system of the British. This august house is today witness to history in the making in the true sense. Because what we are enacting today is a historic reform that will touch the lives of 140 crore Indians, not just for today, but for centuries to come. And while doing so, we are ridding ourselves of a 162-year-old colonial baggage and are moving towards a Swadeshi Vyavastha at the time when Bharat is entering the Amrit Kal of its glorious period of history. I want to thank and congratulate Honorable Prime Minister Narendra Modi ji and a very visionary Home Minister Amit Shah ji for piloting this historic reform of India's criminal justice law. Adhyakji, if you will spend a minute to understand the context in which our criminal justice system came to be introduced by the British, it comes to light that all the three criminal justice legislations, the IPC, the CRPC, as well as the Evidence Act, were enacted right after the 1857 First War of India uprising. First War of India's independence uprising. The objective of the then British government, while introducing these three legislations, was to subject the natives, subject the Indians to such a criminal justice system that will obliterate, annihilate all kinds of possibilities of rebellion. So all the three laws, the Indian Penal Code, the CRPC and the Evidence Act, were all enacted with this intention of subjecting the native population to humiliation and making sure that their self-confidence was always subjected to insults. The British understood that there are two important aspects of a society that need to be controlled to completely colonize and destabilize a native population. One was education, and the other was the criminal justice system. And Lord Macaulay, in his prophetic Education Minute, exhaustively mentions how the British tried to colonize, British tried their very best to remove from the memory, the civilizational memory of this country, our educational as well as criminal justice system that had been in practice for so long in the country. I must say today that when the country is the threshold of Amrit Kal, under the leadership of Honorable Prime Minister Narendra Modi ji, we have enacted the National Education Policy 2020, and today we are enacting these three Sanhitas, which is going to replace the colonial code, and in the true sense, we are moving away from colonization of education and colonization of our criminal jurisprudence. Today marks an important day also, Speaker Sir, because for about 160 long years and almost 7 decades after independence, the country's criminal justice system followed legislations which were made by the British, made for the welfare of the British, and made in Britain. Today, in those places, we are enacting a law that is made by Bharat, made in Bharat, and made by Bharatiyas for the welfare of Bharatiyas. This marks a very important step in our decolonization journey. While we are here, I would want to draw the attention of this House, Speaker Sir, to another important aspect of the British criminal jurisprudence, of how vicious the intent of the British was while bringing and enacting these legislations. One of the biggest examples of this intent of the British is in the example of the Criminal Tribes Act of 1871. Speaker, sir, in 1871, the British Raj enacted a legislation called the Criminal Tribes Act, under which large communities, large tribes were declared as criminals by birth, and they were subjected to multiple humiliations and restrictions. There were police manuals that were drafted enumerating long lists of how these criminal tribes must be dealt with, how they must be punished, how they must be abused. And for a long time, even after independence, Speaker, sir, many of our jail manuals contained these very provisions, and many tribes which were enumerated in these Criminal Tribes Act faced severe humiliations both legally and socially. Many of the major castes of Hindu society, like this was the word that was used by the British. Yes, it is unparliamentary. This was the words that were used by the British. Many of these communities, more than 130, 140 of them, they were declared as criminals by birth. And by 1947, at the time of our independence, more than 2 crore people existed in this country who were criminals by definition as criminals by birth. This was the intent behind the criminal justice system of the British. This is just to show, this is just to explain the monumental difference that we are today making by moving out of the dark shadow of the British's criminal justice system and moving towards a completely Indian and Swadeshi justice system.
I would suggest the names that have uttered should be removed. Only the numericals, 2 crores, that is to be.
With respect to the changes that have been made in these 3 legislations, I want to take a few minutes to highlight some very important changes. Under the BNS, importance has now been given, precedence has now been given to crimes against women and children. And some of the most important changes that have been made keeping in mind the protection, empowerment and justice delivery for our sisters in the country. Not only the precedence in numbering reflects this intent of the government, but also providing for death penalty for gang rape of a minor girl is introduced for the first time. Most importantly, we are witnessing over the last few years a concerted attempt by a certain vested interest groups of suppressing their identity and luring young women under the false pretext of marriage. Even this has been declared an offense, and stringent provisions have been made to punish such attempts. We also keep observing, Speaker, sir, that there are multiple instances of hit and run cases, what we refer in a colloquial term. In most of these hit and run cases, it is always the rich who hit and run, and who are the poor, who do not have access to justice, who do not have access to power, who are left fighting for justice without any support. For a long time, this offense of hit and run was not codified, was not declared an offense. That has now been brought in. As also, offenses like chain snatching and mobile snatching, which is, if you go to any police station today, there is a board always in the police stations. If you will see, most of the cases that are reported in urban areas, at least in the country, are these chain snatching and mobile snatching cases. But unfortunately, we did not have a penal provision to deal with this. This has been added. We have also seen that whenever there are protests, in the name of displaying outrage, certain anti-social elements use that opportunity to damage public property. And public property amounting to crores get damaged. For the first time, under mischief, by expanding the provision, damage to public property has also been made an offence. And hereafter, any anti-social elements who will indulge in any such activity will be facing the music of the law. There were many provisions which were reflective of the colonial and Victorian morality of that era. Both sections 377 and section 497, which dealt with adultery, were a reflection of this Victorian morality. Both of that has been omitted, and we have now truly moved away from a pre-colonial legislation system to a post-colonial indigenous system. Speaker, sir, another aspect that gives us a great amount of joy is that for a long time, the Indian Penal Code was not fully applicable to the whole of India. It was applicable to the whole of India except the state of Jammu and Kashmir. And in Jammu and Kashmir, we had the Ranbir Penal Code that was in existence. With this act and with the abrogation of the Article 370, the BNS will be applicable to all states of India, including the state of Jammu and Kashmir. This is another very important historic step that this Parliament has taken with this enactment. While these are some of the important changes that have been made to the BNS, the Criminal Procedure Code was also crying for reform. Many committees, the mention of which has been made earlier, made reports on reports, committees gave voluminous suggestions, but none of that was implemented by earlier governments. Because the Criminal Procedure Code is that procedural law which is the foundational law on which criminal justice system is adjudicated, delivers justice. But it was the discrepancies inherent in the CRPC that led to the vast number of under trials that we have, pendency of cases that we have, the complexity of criminal justice system that we have, and the whole justice delayed is justice denied kind of a feeling that a large number of people in this country felt. That going to court itself was a punishment, was a vexatious issue. Many major changes are made under the CRPC to address the complexity of the procedure and make it more simple, keeping in interest, keeping the citizen in interest, and keeping the victim as well as the informant, protecting both their interests. For example, it has been provided that no arrest shall be made in any case of an offence punishable for a term of less than 3 years. And if the person has infirmity or is above the age of 60 years, he cannot be arrested without prior permission of the officer, not below the rank of DSP. Speaker, sir, we are aware how in many cases, especially in 498 in dowry cases, senior citizens are harassed even at the cost of false cases that are registered. Even though the Supreme Court in multiple instances, even in Lalita Kumari and many other judgments, has enumerated that arrest should not be made whimsically, arbitrarily. Experience tells us that this was not followed. For the first time, by codifying this as a principle, interests of those people who are weak, senior citizens, are protected from arbitrary arrest. The provision on mandatory video conferencing during search and seizure also keeps in mind the interest, also tries to balance harmoniously the interest of the victim as well as the need for transparent and fair judicial systems. We have also come across in our own experience people coming to MPs, people coming to MLAs with complaints that they went to the police station, but the police did not file an FIR saying that it does not come under their jurisdiction. वो भागते रहते हैं बेचारे यहाँ उधर उधर. By the time he finds out which police station comes under his jurisdiction, time would have lapsed, and FIR and its sanctity would have lost meaning, and multiple instances, cases have gotten quashed at courts because of the delay in filing of FIRs. For the first time, through zero FIRs and EFIR, this paradigm change has been brought in our criminal justice system, where an individual can report a case, file an FIR of a cognizable offense, any part of the country, and it is mandated on the part of the police to register the case and then forward the complaint to the concerned police station for investigation. This is again a very, very welcome move. In addition to that, it has come to our experience that when a complainant or an informant goes to a police station, files a case, after filing of the FIR, he is not aware as to what is the status of the case, what is happening with it. He will have to repeatedly go meet the station house officer. He is not aware, goes to the DCP's office, standing for hours together. He is not aware of the status of the case, status of the investigation. But in this Sanhita, it has been mandatory, provided that the police officer in 90 days shall inform the progress of investigation to the informant or victim by digital means. This is again an attempt at making the citizen the center of the criminal justice system and not the crown. In addition to that, one of the biggest challenges that our criminal jurisprudence, our criminal justice system faced was the abysmally low conviction rates. If you compare our conviction rates to more advanced jurisdictions like Israel or Australia, our conviction rates is abysmally low. One of the reasons for this low conviction rates is the quality of evidence that is submitted before our courts. To address that, especially in serious offenses, it has been made mandatory for forensic science experts to visit the crime scene to collect forensic evidence in all cases that are prescribing punishment for 7 years or more. Speaker, sir, this is a truly revolutionary provision, because not only is this going to enhance our conviction rates, it is also going to protect those innocent, but those who are facing false allegations and false charges. Because one of the foundational principles of an effective functioning criminal justice system is to punish the guilty and to protect the innocent. And that can be done if our quality of evidence, the quality of our quality of evidence submitted before the court is increased, and this is a very important provision in that regard. Speaker, sir, the other big ailment of India's criminal courts is the delay in dispensation of justice. The moment a case is filed, you never know when the justice is finally dispensed with. And going to the courts itself is a vexation, is a punishment for both the victim, his family, as well as the accused. For the first time, investigation, submission of charge sheet, investigation pursuant to filing of charge sheet, pronouncement of judgment, all of these have been time-bound by the statute itself. And even seeking of adjournments, which was a common practice for many lawyers who are in the house who have practiced in the criminal courts, we are aware that seeking of adjournments as a matter of right is a practice seen in our session courts, in our trial courts. And every delayed date creates a burden not just on the exchequer, but also on the families of both the informant, the victim, as well as the accused. For the first time, even this arbitrary adjournments has also been dealt with under the CRPC, where it has been provided that where the circumstances are beyond the control of a party, not more than 2 adjournments may be granted by the court after hearing the objections of the other party and for the special reasons to be recorded in writing. In a sense, this provision will make sure there is mukti from unlimited and arbitrary adjournments, which is a big ailment of this system. We have also seen, Speaker Sir, that in many cases, even serious cases, which has a political color, if there is a change in dispensation, the new government drops the prosecution of these cases. In Karnataka, the previous edition of the Siddaramaiah government dropped more than 1,600 cases belonging to the now banned and declared terrorist organization like PFI to meet their vote bank politics. And in many instances, Speaker Sir, these were very serious cases. Murder, culpable homicide, organized crimes, terrorist activities. More than 1,600 cases were dropped. And in many instances, even the victims were not heard. For the first time, under the amended CRPs, under the new Sanhita, it is mandated that where prosecution is supposed to be withdrawn, especially in cases where the punishment is 7 years or more, the victim side shall be given an opportunity of being heard. This is again a very important step in not only diluting political interferences in criminal justice system and prosecution, but also placing the interest of the citizen, the victim, over and above the interest of the state. One of the points that Ravi Shankar Prasad ji made was about the condition of our under trials. Speaker Sir, I remember when you had made an intervention earlier, when the bill was proposed 4 months ago, you also had highlighted the attention of this House to the condition of our under trials. Lakhs of people who may be otherwise innocent are languishing in our country's jails because the wheels of justice are moving so slowly and painfully slowly. In many of these instances, most of these instances rather, the under trials are young people. Any third year or a fourth year law student who would have visited a jail will understand that 80% of under trials are young people who are staring at a bleak future just because his cases are not being heard properly. In many instances, Speaker Sir, they would have completed more time as an under trial than what they would have faced had they been convicted of that offense. To address that issue, a new provision has been made that if a person is a first-time offender, he shall be released on bail by the court if he has undergone detention for the period extending up to 1/3 of the maximum period of imprisonment specified for that offense. It has also been made mandatory that where the under trial completes 1/2 or 1/3 of the period, it will be the duty of the jail superintendent to forthwith make an application in writing to the court in this regard. Speaker Sir, I want to take a couple of minutes at the end to only highlight some monumental changes that have been made in the Indian Evidence Act. One of the biggest challenges that our courts would face in evaluating and appreciating evidence in today's day and age, where digital, IT, electronic evidence play such a vital part of our everyday communications, was that our Evidence Act was not equipped to handle and appreciate the quality of electronic evidence. The thrust of the changes that have been made in the Evidence Act, which is now going to be replaced by the Sakshak Bill, is the importance placed on electronic evidence, digital evidence, and new age mediums of communication and presentation of evidence before the court. Evidence
as
has
primary
also...
evidence.
Speaker, sir?
As primary evidence. Earlier, some electronic equipments were used as secondary.
As secondary evidence. I'm coming
now,
there, Speaker, sir. I want to explain this with an example. Speaker, sir, you must be aware, the House must be aware, that very recently, in the famous case of, he was acquitted. He was acquitted.
Don't mention the name. That name should
Mention it.
He was acquitted, Speaker, sir, on the premise that the person who recorded the speech did not provide the original DVD-R to the investigating officer. But the speech was broadcast live and millions of people all over the country, all over the world were witness to it. But the court ruled that the digital evidence that was submitted before it was not admissible because the person who recorded the original DVD did not provide it to the investigating officer. So all other copies which were available online, which were available at the time of making of this speech, were not considered either as primary evidence or as secondary evidence and were rejected. This was a major lacuna in our Evidence Act. That has been addressed by expanding the definition of primary evidence. And in the new section 59, in the definition of primary document, new explanation has been added. And a video recording is which is simultaneously stored in electronic form and transmitted or broadcast to another. In such a case, each of the stored recordings is considered as original. So had this bill gotten enacted a few years ago, the fate of that person who made the hate speech would have been very different than what it is today, Speaker, sir. In addition to that, the provision has been also made to provide evidence, make available evidence through appearance of witness, accused, victims through electronic means. We have seen how in many instances cases have gone on forever because either the witness or the expert witness or any other person could not appear before the court physically.
Please conclude.
So all of these are important changes that have been brought to the criminal justice system by the enactment or the introduction of these three important legislations, Speaker, sir. Speaker, sir, I must place on record the gratitude of millions of young Indians today, because I represent the demography in this House, for bringing this monumental reform. Because this is a philosophical change in the way we are approaching our citizens. This is a philosophical difference in the way the country and the country's criminal justice system is viewing our own people. This marks a departure from the colonial era legislations. And Speaker, sir, the United Kingdom and its press were aware that Narendra Modi government will herald and usher in such reforms. And they knew this on the very day that the people of this country gave Narendra Modi the mandate in 2014. I want to conclude by reading 4 lines from the editorial of the Guardian newspaper from the 18th of May 2014. On the 18th of May 2014, just after the election results were declared, and the country's people had elected Prime Minister, elected Modi ji to be the Prime Minister of the country with an overwhelming mandate, the Guardian wrote in its editorial, "Today, 18th May 2014, may well go down in history as the day when Britain finally left India. Narendra Modi's victory in the elections marks the end of a long era in which the structures of power did not differ greatly from those through which Britain ruled the subcontinent. India under Congress was in many ways a continuation of the British Raj by other means." This was an observation, not by an Indian newspaper. This was not an observation done by the Panchajanya or the RSS organizer. This was the observation that was recorded by the Britain's foremost newspaper, The Guardian, on the day the people of this country voted Narendra Modi ji to office in 2014. And what has followed since then is a conscious effort towards decolonization of this country through the education policy, and now through this historic sanhitas which are going to overhaul the delivery of the criminal justice system in India. Finally, the meaning of the word Swarajya has attained true meaning, because the country is moving towards respecting Swabhasha, Swadharma and Swadesha.